This motherfucker, okay, get the fuck out the lane. Like, you are going to get hit. Like, that's why they made sidewalk. Look, what the fuck? You can't drive in the motherfucker on the sidewalk? Why the fuck is he in front of me? Your bitch ass hit.
Hey, I'm not surprised, motherfuckers.
I'm not playing these games, not playing these games at all. Ay. If it's not serious enough for someone to die, don't give me a call. Ay. Won't catch me wiping no bitch. Ay. I cannot fight with a bitch. Ay. I get in right with my bitch. Ay. I keep it slight with a bitch. Yeah. I pulled up with that gauge, then I rearrange his face. 40 pulled his car, that's my motherfucking ace. Yeah, I never pursue shorty. I just fucked her cause I can. Yeah, never knew little shorty. I just met her off the gram. Yeah, but I do not fuck with these niggas. Ay. I am not cool with these niggas. Ay, man, I bust a move on these niggas. Ay, how about a coupe on these niggas? Ay, I am too true to these niggas. I cannot fool with these niggas. Everyone fade, they got attitudes until I pull up and they switch it. Ay, I do not fuck with these bitches. Ay, I am not cool with these bitches. Ay, I bust a move on these bitches. Ay, man, how about a coupe on these bitches? I am too true to these bitches. I let the crew hit these bitches. Everyone fade, they got attitudes until I pull up and they switch it. Bitch. 214 forever. Always and forever.
If you want to come at me for sucking my dick in 2002, we were both doing blow, go ahead, be my guest. Be my guest.
Gang. 214 forever. Love. Always and forever, bitch. Love. I got money, I got gas, I got everything too. Got about 1 million rounds, nigga, I don't cop a few. I got niggas trained to go, tell me what you tryin' to do. But them niggas gon' be mad if they have to come through. What's up, bitch, pull up. What's up, bitch, pull up. I ain't trippin', I got niggas right there in the cut. What's up, bitch, pull up. What's up, bitch, pull up. Got this 40 on my hip to pump in the trunk. Okay, wait, gang, 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 gang. Light as fuck is gas. That's torture fucking weight. Look, I don't claim no hitters, I'm the shooter, bitch. That chopper shoot that 308 pool, bitch. Hop inside the muscle, then I'm out just like Zoom. Walking with the hammer in your house just like Doom. Said my gas, I'm huff, I told her she'll be back soon. When she hit my blunt, it sent that bitch to the moon. Dre used to be nice, nigga, you don't act the same. Boxing ring the rice, how I go against the grain. Acting like you hard, nigga, we all know you ain't. Pull up on my gang, you gon' make me test my aim. I got money, I got gas, I got everything too. Got about 1 million rounds, nigga, I don't cop a few. I got niggas trained to go, tell me what you tryin' to do. But them niggas gon' be mad if they have to come through. What's up, bitch, pull up. What's up, bitch, pull up. I ain't trippin', I got niggas right there in the cut. What's up, bitch, pull up. What's up, bitch, pull up. Got this 40 on my hip to pump in the trunk, okay? Yeah. 214 forever. Always and forever, bitch. Ayy, ayy, look. I come up on some slight shit, 9 niggas hold their hands out. Make your best jump, pull you back in. They don't wanna see you land out. Same bitch ain't fuck with me, now she here trying to pull her pants down. I'm the type of nigga make a move my moms and my fucking mans out. Looking forward to the takeoff with my niggas on some Team Rocket shit. Niggas said they hunting, I ain't nothing, man. Fuck all that ducking and dodging shit. Jab like punching and punch out, that's stand and down. Been working real hard and shit. Type of nigga make a move right now to put some money in my pocket, bitch. Yeah, 12 gauge to the back door, nigga, bust down, bust down, bust down. Yeah, walk then that bitch drop the ball, nigga, touchdown, touchdown, touchdown. Yeah, nigga talk a whole lot of shit, won't run down, run down, run down. Yeah, caught this homie slipping last week, nigga, one down, one down, one down. Yeah, had a bang of rats in the backseat, hit that bitch twice, it's a repeat. Yeah, put brown in a cup like a receipt, got a bitch wet like a Fiji. Yeah, changed my number, now she can't reach me. Then I hit her up, told her meet me. Yeah, then she pull up, blow me like beep beep, then I dip out like beep beep. Yeah, I was trying to keep it real with these niggas, man. They don't know how this shit feel, yeah. I was keeping it 100 with niggas and still they couldn't keep it real, yeah. Then I come through, keep it clean, just need a few mil to split with the team, yeah. Hit them from across the street, I took all the beam, don't wanna be seen, yeah. I come up on some slight shit, 9 niggas hold their hands out. Make your best jump, pull you back in. They don't wanna see you land out. Same bitch ain't fuck with me, now she here trying to pull her pants down. I'm the type of nigga make a move my mom's and my fucking man's out. Looking forward to the takeoff with my niggas on some Team Rocket shit. Niggas said they hunting, I ain't nothing, man. Fuck all that ducking and dodging shit. Jab like punching and punch out that stand and down. Been working real hard and shit. Type of nigga make a move right now to put some money in my pocket, bitch.
When you shining like I am, a bitch won't tell you no. My youngers out here bagging shit, I call them the new Curtis Snow. It's a couple Drakes in here, but this ain't over, yo.
Okay. Nah, this ain't running. Yo, listen, I don't even know what the hell just happened. Hold up. Give me a second, man. Give me a second. What the hell? Okay. Give me 1 second, fam, because I accidentally unplugged some shit. Alright. Now we should be locked in. Alright, so, bruh. Listen. These niggas with this whole YSL case, this shit is rough, bruh. I'm not gonna lie. So what I'm about to show y'all is I'm about to show y'all a couple different things, right? I'm gonna show y'all obviously the things that's inside the thumbnail, right? I'm gonna show y'all this judge right here having this back and forth with Young Thug's attorney. Bruh gets so irritated, he ends up getting up and walking out real live. Like, I ain't even know he did all that, right? Then after that, I'm gonna show y'all where YSL Woody, which is the dude that said that he wouldn't testify even though he got immunity. I'm gonna show y'all him basically saying he might not talk again for the second time. After that, I'm gonna play YSL Woody talking about his relationship with Young Thug. So he eventually does start talking. But he ends up firing his lawyer. And then I'm gonna even show y'all the sentencing of Young Thug's lawyer, because if you don't know, bruh got locked up. But let me just go ahead and just play this thing right here. We gonna talk about it throughout my stream. I'm probably gonna stream for only like an hour. I'm gonna jump off for maybe like, what time is it? 11:18, 12:18. We going for 12:18. If you get in the chat, jump in the chat, say something in the chat. I'm gonna bring the chat up on the screen. We could talk. I'm always stop and talk to whoever make any statements in the chat. No matter what it is, you say anything, I'm gonna address it. But anyway, let's just go ahead and play this real quick, man.
All right, you can make it right now. Is he out?
Let me know when you get down to
Is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the courtroom. Come and get you that.
Thank you.
So if you don't know,
Yo,
this is Young Thug's attorney right here. This is the one that got arrested yesterday in the court, and basically this is the whole conversation they had before and everything. Just play it.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love.
So Mr. Copeland is YSL Woody, all right?
The lawyer for Mr. Copeland and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have...
So listen, this is the kill, man. The kill is basically what they're arguing right now is that when the meeting is happening between the prosecution and the judge, the defense, which is him and Young Thug, the defense attorney has the right to be present to hear what's being said. That's what his issue is right here. He's basically calling out the judge and the prosecution team for doing something backdoor ass shit and not communicating and not allowing him to be in on what it is that they talking about. So that's what his issue is, and that's what he's
have some problems.
We can have his. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information. Then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you in.
Listen, you fucking idiot. We don't give a damn about who told him, nigga. We want to know why y'all doing some backdoor shit, man. That's what we want to know. That's what he asking you, Slim. And if he's saying what he's saying is that's the law, that has the constitutional right to be present, fuck where he got it from, nigga. Why you not upholding the Constitution like you supposed to, like you sworn under oath to do so, Mr. Judge? Make it make sense. Make it make sense, bruh. You can't, bruh, because you're doing some fluke ass shit, and that's why your ass is getting mad.
I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. Mr. Adams back.
There you have it. Your man, real life, did jump up and dip off. Run it back.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told.
Bro, why your man's getting upset though? Fool, y'all the ones doing the fluke ass shit, man. Y'all the ones on goofy time. Then he said, okay, how'd you get the information from my chambers? Bro, that's not the discussion, nigga. Y'all are moving fluke like. That's what he talking about. Bro, real life gets up and dips off talking about you got 5 minutes.
Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. I don't think Mr. Adams is back. I have a.
He is. He's right behind you.
Sorry. I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to the.
Is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the courtroom. Come when you get your license.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love.
Ladies and gentlemen, please stay tuned as we attempt to commune with the devil.
Stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said.
I don't know what just happened. I don't know if the jank just started looping out. But as you heard, as you've seen, your man was upset. He got up, dipped off.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. I was ex parte.
That is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing.
That happened, right? And then what ends up happening after this basically is he ends up getting arrested. The Young Thug's attorney ends up getting locked up and ends up being held in contempt for not telling the judge what happened.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information?
Pause. Hey, listen, for the 5 people that's watching, do y'all think Young Thug is getting out or not? Jump in the comment, jump in the chat, the live chat. Tell me, do you think Young Thug is going to be able to beat this case or not? Because it looked like a shit show to me, but I want to see what y'all think.
And it is not covered by work product. There's only one way you could have gotten him. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is who?
I'm Millie, a content creator, coach, and business owner. If I had to start my business from zero, I would have focused on.
How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said.
The judge is more concerned with how the hell the information got leaked, other than him doing some backdoor ass shit allegedly, which he wasn't supposed to do, according to Young Thug's attorney. I don't know. I ain't a lawyer. I ain't a judge. But something does seem off. From my understanding of the law, they're not supposed to meet without him being present. If I'm not mistaken, that's my understanding.
You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a...
When I got this information...
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon...
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it.
Hey, listen. Hold up. Before I let Shorty talk, right? This is the funny thing about the people that are supposed to be enforcing the law on all of us, bro. Because just like judges, and this is from some experience I even know my goddamn self, just like police officers, these motherfuckers don't even be knowing the law for real, bro. They have an idea of the law, but they got to update themselves constantly. And when things come across them, what they're supposed to do is refresh their memory on it. If they ever even touched it in law school, right? But they're supposed to go back to it, read the law for what it is, and then apply themselves to follow the law. But a lot of times, these motherfuckers don't even sit there and know the law. They do what they think. And just as you can hear Young Thug's attorney is saying, have you read the Jane? It says right here that outside of the presence of the accused, you are not to have these said conversations. And the accused is Young Thug. You are not to have conversations without his attorney being present with the opposing counsel and the opposing counsel's witnesses. Because that's just like that is a huge conflict of interest. That's a huge conflict of interest, because if you got prosecution over here trying to hem up the defense, which is Young Thug, and the judge is talking to the defense, not the defense, the prosecution side, and talking to the witness, bro, you can literally persuade the witness. What the hell are y'all talking about? What are y'all talking about? That's the question. That's what his issue is with them right now. What the hell is y'all talking about with this goddamn witness whose word is going to be heavily weighed in this case against the person I'm defending? What the hell was y'all talking to him about? That's why he's supposed to be present, to understand what's being talked about and to make sure that these motherfuckers ain't trying to persuade and tamper with the witness to get on stand to say whatever, some crazy ass shit, man. But anyway, the prosecutor, this is this lady right here. She's about to say something. I want to see what she got to say.
Yes, John. And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it, and then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, Paragraph 12.
You've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, ma'am. Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer.
What if you could do SEO smarter and faster?
Hey, take this time right quick to
you can edit
subscribe
your
if
meta
you're not
tags
subscribed
page
to my
by
account
page
right quick,
or all
man.
in one
I'd
go.
appreciate it. Jump in the chat too,
Modify
man,
your
if y'all
URLs.
haven't. Well, I see nobody has jumped in the chat, and you got to tell me, is Young Thug getting free or not, man? You got to tell me what y'all think, bro. I'd appreciate it.
The reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets
Hey, yo, why Shorty
relayed.
reading like that, bruh? I mean, she not even reading. Why she talking like that? She talking like she talking like she unsure about what she even saying right now. I'm not gonna hold you.
That information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants. We cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately.
Today, Junior, goddamn.
Or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot.
So listen, Shorty talking like, she talking like, you know how like them little kids, like when you was in school, how little, like kids that couldn't read used to talk and read, basically. That's how she talking right now. Shorty, spit it out, goddamn.
And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Have a cat? Stop scooping cat litter with Litter Robot, the highest rated self-cleaning litter box that removes.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte.
All right, man. Listen,
And
I don't think I'm about to sit here and play too much more of just what they got going on right now. I do still have, like I said, YSL Woody, where he's basically saying like he might plead the fifth for the second time. I'm still gonna show y'all him talking about Young Thug. He does eventually start speaking, fires his attorney, and even I'm gonna show y'all even the sentencing of Young Thug's attorney after getting arrested in the court on this day right here. But I'm gonna play like a few more minutes of it. I'm trying to get straight to the point, and we're gonna move on to the rest of that, so I can show y'all the rest of what.
What is it, Mr. Sharp?
Thank you, Your Honor. As you know,
we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, so
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for. and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial is denied. Okay, are you saying thing? You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Arjun Matthews here on behalf of Mr. Mark Williams Huey.
Okay.
We are also adopting all the arguments that have been made by
Officer.
Attorney Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time, and when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got that based upon it. Again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on, even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Garner?
America's beverage companies are working together to deliver more great tasting.
Listen, they all asking for a mistrial at this point. Seems like the rest of these lawyers that are sitting there are all saying the same thing, that there should have been some type of notice given to them about this ex parte meeting between the judge and the witness. Seems like that's about right, but anyway.
Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody, and once he clears the area, we'll go ahead and get started.
If by that point we'll get started, resume the trial.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without stealing.
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir. Sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you, at this point in time, there is nothing that was given.
This is the part where they're about to take Young Thug's attorney basically into custody, man. It's only 2 minutes and 30 something seconds left of this, and then I'm gonna move on because I've definitely went beyond the time that I thought I was gonna be on this chain. I thought I was gonna be off around like 12:18. I thought I was gonna do a smooth little hour, and that was gonna be it. We probably not jumping off this until like 12:45 now, bro. If you on here, I appreciate the likes, man. The 3 likes that I got. Hey, if you on here, to the 4 people watching, I appreciate you. Hit that like real quick, and also jump in the chat if you feel. You can see the chat is on the screen, so your chat will be presented upon all of us, man. But anyway, let's continue.
Said whatever this morning that
If there's any accuracy to some of the information that we are.
But sir, I don't even know your co-counsel. Your co-counsel won't even tell me who said whatever. Okay, and the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been.
Okay, well then you've made it. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You deny the other people.
I denied your motion, but I'll certainly take that under advisement, sir.
All right, goddammit. So, as you've seen, Young Thug's attorney gets locked up.
Take Mr. Steele.
Hold up. Stop that, right? What I did want to play, I had this little on Instagram. Give me a second. What other lawyers were saying about Young Thug's attorney getting arrested. I want to read the what these people have to say about that. Other lawyers, right? It say lawyers react to Brian Steele, which is Young Thug's attorney, being taken into custody. So this is what's being said. It says, obviously the source was the lawyer for the witness, and obviously it is wildly improper to try to swear that lawyer to secrecy. So, wait, hold up. My bad. I should have read this first. It says, whoa, Brian Steele is now confronting Judge Glaville about an ex parte conversation between the judge, the DA, and the witness. Steele says this violates Georgia Constitution. Judge Glanville Judge Glanville wants to know how he found out. Steele refuses to say. Then this person, Andrews, goes on to say, obviously the source was the lawyer for the witness. Obviously, the source was the lawyer for the witness. And obviously, it is wildly improper to try to swear that lawyer to secrecy. So I think what they're saying, this person is saying, is that the source was the attorney to the witness, which is the other guy. The prosecution and the DA had a meeting with the witness and the judge. And this person is saying that the attorney for that witness probably relayed that information to Young Thug's attorney. Which, if they're not combating each other, would make sense. But anyway, I'm going to continue. It says, I mean, I know literally nothing about this case, but how could a judge have an ex parte with a DA? That's what I was saying. How could you have a private meeting with the DA with a witness? That doesn't sound right. Continue. It says the judge seems to concede that it was an ex parte conversation with the DA to persuade the witness to testify. And it strikes me that they didn't want Brian Steele there because he would have correctly objected to it. Right. So basically, if you don't know, the witness is refusing to talk. He invoked his Fifth Amendment, which is the right to remain silent, even though he was granted immunity to speak and to testify. But anyway, I'm going to continue. Now, this man comes back and says, I mean, how does that not instantly end whatever case this is? And then they go on to say, if this case ends, it's only going to because other court steps in, I suspect. We got a little bit more. It says this case and judge is off the reservation. This is an instant mistrial. I cannot believe the judge thinks taking a defense attorney into a custody isn't a mistrial. Brian Steele is a real one. Defense lawyers across the country should be terrified by the lack of judicial knowledge. Yeah, bro, it just doesn't make sense. It just doesn't make sense, man. But let's continue. Let's continue. Give me a second. What I got next is, I'm not going to show this whole thing.
I am here to tell you today that your feelings are valid. Your trauma
I'm not going to show this whole thing.
is valid. Your hurt is...
So this right here. Give me a second.
The published once it's submitted with the court's ruling.
All right, so this is YSL Woody right here. This is the dude that's, from my understanding, is the one that they had the meeting with. He's refusing to testify. And basically this is him testifying again. Well, they're trying to get him to testify again.
Mr. Short, any further objection to state's I'm sorry, I didn't. 380? Yeah, 380. No, you're okay.
All right. First one, published 358 Yankee. And looking at 358 Yankee, can you tell the jury, or tell the jury which of the two of you is little D or who you call your son? Which one? To the left of you, right of you?
What you mean?
Is that little D to my right?
This little D in the picture with me.
Okay. And do you know about how long ago you took this picture?
No, I don't.
And we keep saying little D or your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said Demikian Garlington.
Okay. And is that the person that you know is little D?
This little D right here in the picture with me.
And is that Demikian Garlington?
This little D right here.
Is that Demikian Garlington?
If this was your name, then yes.
Okay. Now showing you 380 Yankee. And can you zoom in to the picture?
Man, I'm not about to sit and play too much of this, man. I'm not going to hold y'all. I am tired. And I've had a bunch of people jump off. I had 28 people watching at one point. that has diminished significantly. I'm not gonna lie, man. I don't know why y'all just be jumping on my Jane and jumping off, but we just gonna continue, bro. Anyway, I'm gonna just go ahead and play.
Do you know someone by name?
Him talking about his relationship with Young Thug.
Or Jeffrey Williams.
I heard of he's a rapper.
Okay. Do you know?
I know him. I don't know him as Jeffrey Williams. I know him as Young Thug.
All right. And when you say you know him as a rapper, have you ever spent time with this individual?
Yeah, I did.
Okay. When is the first time you recall, strike that, what do you refer to him as?
Young Thug.
Okay. When is the first time that you recall meeting Young Thug?
At the studio.
And roughly, what year are we talking about?
Before I went to jail.
Which time?
Right. Before that, I went to the feds.
So before 2015. Do you see him in the courtroom today?
Yeah.
Can you identify him by article of clothing he is wearing?
Brown. With dread, sitting next to the bald head guy.
All right. Is anyone else on the other side of him?
We'll stipulate Ms. Williams sitting next to him.
Okay. All right.
Thank you. You said that you met at the studio. How did you meet him at the studio?
Through a friend.
What friend?
I really didn't meet him. I just saw him at the studio when I was with a friend.
What friend were you with?
I asked him, can I take a picture?
What friend were you with when you saw him at the studio?
Doc.
Was there anyone else?
Huh?
Was there anyone else?
There's a lot of people there. I don't recall who all the people was.
Do you recall if Tick was present when you first met Miss Young Thug?
I can't recall.
You said that you met him at the studio and you asked to take a picture with him. You're right, I'm looping the questions. I can get to my next question. When you met him at the studio and you took a picture, did your friendship or relationship develop after that time that you met him at the studio?
What you mean?
Did you all develop a friendship?
Did we develop a friendship?
Yes.
My definition of a friendship is not just knowing somebody or knowing who somebody is.
Okay. Did you start hanging out with him?
I started going to the studio a lot.
Okay. Did you start hanging with him outside of the studio?
I have.
Okay. When you hung with him outside of the studio, where type of places would you hang out with him at?
But most of the time, he liked to be in the studio.
Okay. My question is, when he was not in the studio and you hung out with him, where would you hang out with him at?
We used to do fun stuff.
With Norwegian, wake up to a new city nearly every day. Come aboard.
Like, go to bowling alleys and stuff like that. He went to the kids' football game, I remember. I've been to the club with them. I've been on shows, I meant, correct that.
You saw on shows?
Yeah, like when I watch him perform.
All right. And is this, the shows, the bowling alleys, the club, are we talking about in 2014, 2015, or some other time?
2014 only.
2014 only. in 2014, about how often would you see each other on a monthly basis?
I don't keep up with that type of stuff.
Okay. Did you see him a lot in 2014? Was it quite often? Were you always around? Or did you see him once in a blue moon?
Well, to know that he was a rapper and successful, I seen him a lot. To me, I think I saw him a lot.
Are you referencing like seeing him on television or being around him in person?
What you mean?
You just said, because he's a rapper, I saw him a lot.
Yeah, because you don't see rappers a lot. So,
and I'm sorry, I just want to clarify. When you're talking about seeing him, are you talking about physically being in his presence or seeing him like on television?
I knew people that be around him.
Okay.
And I used to see him a lot. Every time I saw him, I saw him. I was happy to see him.
Besides seeing him in person, would you ever speak with him over the phone?
Meaning?
Did you ever talk to him? Let's first start old school. Pick up the phone, dial some numbers. Would you ever talk to him over the phone?
Have me and him had conversations?
Yes.
I can't recall if we did or didn't.
Okay. Let me ask you FaceTime. Have you and Mr. Williams ever FaceTime with each other?
I can't recall.
You can't recall. Let me just ask you generally, in 2014, with any of your friends, Shannon, Little D, Yak, well, you said you didn't speak to Yak. Would you FaceTime any of them?
Say that again?
Shannon and Little D, would you FaceTime them back in 2014?
I don't like FaceTime.
I know you don't like it. That's not my question.
That's what I'm saying. So most of the time I talk on the phone, I call regularly.
Okay, but have you?
I don't recall talking on FaceTime.
You don't recall talking on FaceTime?
Not that I know of. Not that I know of. And I don't. You have to ask that again because I ain't for sure what you're asking.
Sure. I'll ask you again. 2014, 2015. Have you ever? I'll wait till you finish.
I'm tired.
You went.
Listen, is this nigga attorney? I think this is the prosecutor. This is the prosecutor. Yes. This is the prosecutor. Cause bruh acting about irritable as he possibly can.
When I vote. Okay.
I'll stand the objection.
Back in 2014, have you ever FaceTimed with Little D? Ever? Back then.
Lil D?
Lil D.
How I supposed to remember that?
Do you recall ever FaceTiming with Little D?
I don't.
Okay. What about Shannon?
I don't.
Okay. What about the person you identify as Young Thug?
The person I identify as who?
Young Thug.
I don't.
Okay. What about you said no to Yak?
If I FaceTime with him, I probably screenshot it and post it on social media just to show people that I probably was on the phone, but I don't remember if I ever did have it.
Okay. Now you said that you would spend time with him, whether it's the studio or in other places. Were you close to Young Thug as you were Shannon and Little D?
It's not established on her foundation.
I'll stand the objection.
All right.
Did you speak often with Young Thug back in 2014? Did you talk to him often?
Not that I recall.
Not that you recall.
All right. So listen. Jesus fucking Christ. I'm not gonna lie. I don't know. I hate court, bro. I hate court. Being in court myself, I hated it. Excruciating. Like we've been on this thing for an hour and 15 minutes, yeah. Real live, a whole motherfucking hour and 15 minutes, just going over the clips. Now I see why the judge and why this nigga and why everybody just seems so irritated, bro. This shit gonna take forever, bro. I wonder how long it's gonna take for these fools to finally get to the end of this. But anyway, that was YSL Woody. He ends up firing his attorney. That's what I'm about to
Before
play
we
next.
call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of point in time?
She fired. Bro, don't take this shit serious at all, man. You know who YSL Woody remind me of a little bit whole time? Low key, he remind me of Lil Reese, Jai like. I don't know what it is, but he Jai like remind me of Lil Reese. I ain't gonna hold you.
Is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
Well, you can keep your lawyer that you have right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
Do what I need a lawyer for?
It's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Thomas, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
Well, Judge, just for the record, I'll say that his counsel.
Say again?
I was never his counsel. Attorney Melvin was his counsel, and I was stepping in as a courtesy for judicial efficiency. Motions of withdrawal.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have, because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
Right?
You do, yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you got to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw. But you're on the stand. You're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just would like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance. So to file a proper notice to withdraw, I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Shorty over it. She like, man, I'm trying debt, bruh. I wonder what the hell happened. I wonder why he said she fired. Like, I wonder what happened, bruh.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Can we approach? Can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
All right. Stop this. It's the last thing I'm going to talk about while I'm on the show before I get off. Appreciate anybody that's been watching.
Mr. Copeland here, so go ahead, Miss Hilton.
If you've been watching this whole time, which I don't know because I don't know. That's all I'm going to say.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends.
Wow, that is unbelievable. This is Bob Bianchi here at the Law and Crime Network. We're going to be taking live coverage for the next 2 hours, and you heard it right there. Attorney Brian Steele, who is representing rapper Young Thug in his Georgia racketeering trial, was held in contempt of court on Monday afternoon and was actually sentenced to jail time. We're going to talk about that. I'm talking about a criminal contempt of court. The drama unfolded when Steele brought forth knowledge of an ex parte. That means a conversation that happened outside the presence of counsel and not in the courtroom. A conversation that supposedly took place before the court began, involving the judge and prosecutors, where the state's witness, Kenneth Woody Copeland, allegedly admitted to killing Donovan Thomas Jr. Before this, Copeland, who is a convicted felon, had finally agreed to testify after having been arrested last Friday for invoking his Fifth Amendment right in front of the jury. Criminal defense attorney Ashley Merchant, who is also the president of the Georgia Association of Criminal Defense Lawyers, represented Brian Steele in trying to obtain his release from custody after the jury was excused. Merchant is representing co-defendant Michael Roman in the racketeering case against former President Donald Trump. Rapper Jeffrey Williams, who is known better as Young Thug, stands accused, along with 5 other co-defendants, of violating Georgia's Racketeer Influence Corrupt Organization Act, also known as RICO. Young Thug is also accused of participating in a criminal street gang known as YSL, which stands for Young Slime Life. Now, this is really, really an unbelievable honor to be able to have Ashley Merchant actually with us right now. Ashley, I got to be honest with you. We said this before we went on there. I knew you are the real deal. I watched you making this argument in court. When your client was first held in contempt, my tweet out to the world was, wow, in all the years as a trial lawyer, with all the friction that's happened between attorneys and judges, I've never seen a judge for something is like this hold somebody in criminal contempt, especially without a hearing and without recusing himself, as he is a witness. These are arguments you very eloquently made. And if anybody wants to know, go to our executive producer, Kathy Russin's Twitter feed or wherever Kathy is, because you can actually see Ashley Merchant making the argument that it's not right. Ashley, last point. As a prosecutor for most of my career, and now as a criminal defense attorney, I don't care what side of defense I was on, I find this to be repugnant to the administration of justice and chilling to attorneys who are making forceful and efficacious arguments to a court. This judge was out of control in my mind. What's going on down there in Fulton County? Seems to be a lot of arrogance by people in positions of authority. Wink, wink.
I know Fulton County is in its own league at this point. It was shocking to me as well to have a.
And I heard you quit.
Things change. This is not a typical murder case.
This is delightful.
It didn't need to end this way.
Precisely.
A member of our bar, an esteemed member of our bar, which I think you could see if you were watching the live feed. He had a lot of support, but Brian Steele is beloved in our community. He is a nationwide known criminal defense lawyer, has a wonderful reputation. And so we were all honored to come to his defense. It was unfortunate that it was needed, though, because all he was doing was zealously advocating for his client. And what appeared to be the judge being caught doing something wrong himself sort of deflected and said, oh, well, now I want to know who actually outed me. I want you to snitch on whoever it is that told you this. I want to deflect from my wrongdoing and try and turn it around.
Judge,
and
just for the record, so
Ashley, let's drill down a little bit more about where this began. Okay, so ex parte communications, that is without one of the other sides present, is an extremely unusual and very coveted thing. It's got to be done for specific reasons. But please explain to our audience I've actually had a case where this happened to me. Prosecutors were allowed in chambers with a judge with a sworn witness who now decided he was going to testify. And what was the argument that Mr. Steele was making?
It is unheard of, as you said. Normally we have very specific reasons that you can have an ex parte hearing, and this is not one of them. This witness was in the middle of testifying, had been incarcerated for not being willing to testify. He said he had a Fifth Amendment right to remain silent. He was exercising that, and he spent the weekend in jail. And everyone expected him to come back to the stand Monday morning, testify. All of the defense lawyers were sitting out of the courtroom for a couple hours while the state and he was the defendant in that action, the actual person who was held in contempt, the witness, he was back in closed door and chambers having this ex parte communication about whether or not he was going to stay in jail for contempt or if he was going to testify. That's just unheard of, but ex parte essentially means that the defense is not present. So none of the defense lawyers, Brian Steele and all of the other defense lawyers, they didn't know about this meeting. They weren't able to participate in this meeting. So it was completely ex parte, completely behind closed doors. And they wanted a copy of the transcript. They wanted to know what happened. They wanted all of that information. They're entitled to all of that. What they were asking for is not unreasonable. It's something that they're legally entitled to. And Judge Glanville denied it and then held them in contempt for not being willing to divulge how they found out about his misdeeds.
Yeah, how dare you find out about something we did that wasn't right? And if you don't tell me who told you, I'm going to throw you in jail. Now, we're going to get into and carve out the maybe attorney-client privilege, or the privilege goes beyond that. It also goes to information that goes beyond even what a client may tell you. But we'll get into that in a minute. So do I understand that the gentleman who asserted his Fifth Amendment right, this witness that the government wanted on the stand, was literally in the judge's chambers when this was, it wasn't just lawyers, he was there as well, and the argument is he was being coerced and threatened to testify?
Yes, that is right. And it is unbelievable. I mean, it just sounds unbelievable. Like you couldn't make something like this up. So the prosecutor asked to have this in camera, review where they went back in the court's chambers. They had a court reporter, decided to invite a court reporter, but did not decide to invite the defense, and discussed how long he would have to remain in custody if he refused to testify. So the state had given him immunity for his testimony, but he still said he wanted to plead the Fifth and didn't want to testify. And so they were discussing that and discussing how long he would be held in custody if he did decide not to testify. That's something that the defense has a right to know. That's something that they should be able to cross-examine this witness on if he changed his testimony based on that.
Yes, I was just going to say to you, I mean, the defense has an absolute right for expectation of benefit, or for whatever reason or whatever conversation may have occurred in order to impair his credibility, to bring out what happened. How is the judge possibly, we can put park the contempt aside right now. Is the defense in possession of the transcript and what was said during that ex parte conversation so that the motives of the witness can be explored?
No, and they all asked for it yesterday, and that's what Mr. Steele was arguing about and was asking for when this contempt happened. And then at the end of the day, all of the lawyers again asked for those transcripts. I asked for a copy of the transcript because I thought that it would be important for our appeal, because we're able to appeal immediately, an emergency appeal of the contempt finding. And I thought it was relevant. I think that everybody should be entitled to it. And what the law says is if you inadvertently have this ex parte, let's say that the judge had this ex parte and said, oops, I forgot to invite the defense. The law says you can remedy that by immediately telling everybody what happened. So the remedy is to give them the transcript, and they're still refusing to even do that.
Yeah, so I mean, it kind of makes me think that the judge is saying, all I want to know is the name of the person. Well, that may be the reason the judge said that is so that he can maintain the integrity of the proceedings, but that doesn't mean you don't give him the transcript so he can cross-examine the witness. This is a major faux pas, and as a former prosecutor for probably more than I've been a defense lawyer, I would be very worried that if there's a conviction in this case, that this is a substantial matter on appeal. They are walking through a bad door here. Last point that I want to ask you, Ashley. Now, you made very articulate arguments, and I want you to explain to our audience when you were trying to pigeonhole the judge, and you did such a good job. I knew you were doing it. You were holding your tongue and hope, but you were really getting there about the difference between a criminal contempt in the face of the court that could interrupt an actual proceeding as opposed to a civil contempt where you're actually trying to force the witness to give information, and that the judge found this to be a criminal contempt. Explain this difference. And in Georgia, explain to me, because at least in Jersey, where I practice law, and I'm pretty sure in New York, if you're going to hold somebody in criminal contempt, you have due process rights to be noticed, you have a right to a hearing, and you have a right to a hearing outside the presence, actually with another judge, because the judge holding you in contempt could be a witness. Talk to me.
Right. And so that there's different standards for civil and criminal. So essentially what Judge Glanville was doing was he was taking what was good for him from the civil rules and what was good for him from the criminal rules and merging them. And that's not how it works. You don't get a civil penalty and then follow the criminal rules. So what he essentially wanted to do was he wanted to hold Brian Steele in custody until he talked. That's what he wanted to do. And that's civil. That's a civil contempt. That's something like if, your viewers may understand child support. Let's say someone doesn't pay child support. They can be held in custody until they pay the child support. That's what he wanted to do. He wanted to hold Brian Steele in custody until he squealed, until he talked. That is civil. But he said, well, I'm holding him in criminal contempt. Well, criminal contempt does not allow you to hold someone in custody until you talk. Criminal contempt is a punishment. It's not something that can be remedied. You can't purge yourself. You can't, do an action to get out of it. It's something where you have a certain hearing, you have due process rights. And if he wanted to hold him in criminal contempt, that's fine. Let's just do it the right way. And the right way, it's criminal. It's guilt beyond a reasonable doubt. You have witnesses testify. Someone has to swear on the record about a criminal contempt. It is guilt beyond a reasonable doubt. You have a right to witness list. You have a right to notice of what you're being accused of. He didn't have any of that. He didn't even have a hearing. I asked the court reporter at the end of the day, can I get a transcript of the hearing? And she just looked at me like, what hearing? There was no hearing. It was just this summary criminal contempt without any of the due process. And the biggest thing was another judge should hear it, because who is the biggest witness in the room? Judge Glanville. He witnessed the ex parte. He witnessed this alleged contempt. He is the one who needs to be taking the witness stand and questioned. So he needed to refer this to another judge, and he was just unwilling to do that.
Now, Ashley, you're president of the Criminal Defense Association. Obviously, you're a sophisticated and very, very good lawyer. I was very impressed. Like I said, don't say that often about many trial lawyers out there. Yeah. But I got to tell you what, you got some solidarity, at least from a lot of lawyers up here, myself included. One of my guests that's going to be on the show to my left right now, I can see her vigorously shaking her head in the affirmative. And I think it's a sad day. I think the judge lost his composure. That's what it seemed to me. He got himself and went down a rabbit hole that he couldn't get himself out. But, judges have an authority, but not, in my opinion, that much authority. And I hate to tie these two things together, but I couldn't help but think, there's another incident that's going on down there in your county. And as a former prosecutor who ran an office that had her job, it's not a question of whether there's maybe illegality associated with it. you know better than to do this. You have an instinct never to do something where your propriety can be taken into question. Mm-hmm. So when the judge did this, who I found to be pretty reasonable and doing a pretty good job, it just seemed to me like, wow, there's like a power thing going on down there where people think they can do whatever they want and that there's not going to be any repercussions. Am I wrong to draw those parallels?
You are not wrong at all. Fulton County is a league in its own. I used to be a Fulton County public defender. I spent the last 20 years litigating cases in Fulton County. It is its own system. And what you're saying is completely accurate. The checks and balances don't always apply in Fulton County. And to your point, this is the same prosecutor's office that Fonnie Willis runs. She is the prosecutor. Yeah. So she could have put an end to this. Her prosecutors are the ones that did this. Mm-hmm. They are just as liable for an ex parte hearing as the judge. They are the ones, like you said, who have a duty to step back and say, you know what, this isn't okay. This is not how we should be proceeding. And that didn't happen. And I think, it shows the systematic issues that we have in Fulton County and that we have historically in this jurisdiction. And we all thought when Fonnie Willis ran for office that she was going to fix it because her predecessor had years and years of, indiscretions and issues and things like that. And so we were all very hopeful that it was a new day. But unfortunately, it hasn't been.
Yeah, I have to say it is coming loud and clear to those who are used to a different kind of system of justice mm-hmm. down there. But you know what? When people have always asked me the question, how could you have been a prosecutor and be a defense lawyer? I think you can put this in a box and put a bow on it for the answer as to why criminal defense attorneys, but not just the arrogance of power, but tampering potentially and coercing a witness in the substantive case itself. Ashley right. Merchant. Thank you so much. Great job. Keep up the good work. And I'm definitely going to be following you now. And on this note, we're going to take a quick break. We'll be right back. Thank you.
Thank you.
You got it.
All right, fam. All right. Sheesh. That's an hour and 36 minutes. How the hell do these niggas be doing 4, 5, 6, 7, 10 hours on stream? Maybe I'm just tired because I just got finished doing a 12-hour shift. And it came on here to jump on stream. But this is it. That's it. I appreciate anybody that stayed around listening, watching, subscribe. I appreciate y'all. I'm going to be going live every Monday and Tuesday, bare minimum, at around 10 p.m. And some other day. Hey, I appreciate whoever that was that just liked this joint, bro. I really appreciate it, man, because killing myself to do this because my channel was much better at 2 months ago or so, and too much was going on. I couldn't stay consistent. I just couldn't as much as I wanted to, but we back on, man. I can do much better if I just do it live and not all them individual videos like I was doing. I can cut the videos up. C to M, A, I appreciate you. Hopefully I pronounced that correctly. I appreciate that thumbs up, definitely. Like I said, I will be getting on live much more Mondays and Tuesdays for sure, 10 p.m.s, and some other days during the week. But I'm definitely make posts like the little community posts saying the days that I will, other than Mondays and Tuesdays. But appreciate you. I'm out of here, and I hope y'all have a good night, man. I'm out.